Good evening, everyone. Thank you for your patience. Welcome to our CPD on the New South Wales Security of Payment Legislation and Statutory Demands. My name is Andrew Gergis, and I'll be presenting with Dinesh Ratnam and Declan Byrne. Dinesh practices across all areas of commercial law, including in insolvency, and Declan practices primarily in building construction law. This evening's CPD is really about how those two different practice areas can interface. It's a particularly topical issue at the moment because, for example, just a few weeks ago, ProBuild, one of the largest construction companies in Australia, was put into voluntary administration. What I propose to do is essentially start out by mapping out how this presentation is structured, and I'll give a brief overview of how these two statutory regimes interface. Dinesh will then speak to some of the issues which arise where a statutory demand is premised on a judgment obtained under the SOPA Act, and Declan will take over and explain. After that, Declan will take over and explain the contentious issues where a statutory demand is premised on a debt or an adjudication certificate, but without a judgment. There's always been an interrelationship between the security of payment legislation and insolvency. The Security of Payment Act is a remedial piece of legislation. It's directed squarely at preventing insolvency in the construction industry and maintaining cash flow. In 2012, that interrelationship was the subject of the Collins Report, which arose from the New South Wales Government inquiry into the construction industry and insolvency in New South Wales. And the High Court itself has acknowledged that the policy objective underpinning the Security of Payment Act, not just in New South Wales but across the country, is to provide an interim form of relief via a brutally fast payment system and a scheme whereby payment claims can be made under the legislation and recovered in a short period of time. The Act itself was enacted to eliminate the practice of developers and contractors delaying payment for work carried out by contractors, which put a lot of pressure on subcontractors. And that's something that was really borne out in the Collins Report as being a key contributor to insolvency. There have been a number of interesting developments in the law around whether the legislation itself can be used by companies in various forms of external administration. At present, there have only been two appellate decisions relating to companies in liquidation. The first is in 2016, where the Victorian Court of Appeal construed the equivalent provisions of the Victorian legislation and said essentially that a company in liquidation could not invoke the provisions under that Act. 3 years later, the New South Wales Court of Appeal, constituted by a 5-judge bench, came to a completely opposite determination. The court held that a company in liquidation was entitled to the benefit of the Act. And then 7 months later, Section 32B, an amendment, came into force in the New South Wales Security of Payment legislation. And that provision now prevents a company in liquidation from serving a payment claim or taking action to enforce a payment claim. So how does this legislation work? At a very high level, the New South Wales Act operates in the following way. First, it creates a statutory entitlement for a contractor to serve at least one payment claim each month. And that's in Section 13 of the legislation. From that point onwards, a respondent has a maximum of 10 business days to respond via a payment schedule. The time can actually be less if the contract provides for a lesser period of time. Now, there's some nuances to what actually constitutes a payment claim and a payment schedule, and those sections there, Section 13 and 14, set out what needs to be included for a valid payment claim or a valid payment schedule to have been made under the Act. And that's the subject of a completely different presentation. For present purposes, it's enough to say that where in Scenario A, there's a failure to provide a payment schedule and or pay part of a payment claim, a statutory debt arises, or an entitlement to enforce a statutory debt as a judgment arises under the Act, and that's in Section 15, subsection 2, subsection A, Roman numeral 1. Alternatively, the contractor who's issued a payment claim has an entitlement to lodge an adjudication application and then obtain an adjudication certificate, which they can then register as a judgment debt. And so where you have a statutory demand that's premised on either one of those two scenarios, there are certain issues that arise in relation to whether it can be set aside and in the circumstances in which it can be set aside. And Dinesh will speak to that shortly. The second scenario, Scenario B, is where there's no judgment obtained. So less frequently, a claimant might seek to make a statutory demand where a claimant has in fact served a payment claim, but they've not then taken the extra steps required to obtain a judgment as a statutory debt. Alternatively, they might go through the adjudication process itself and obtain a certificate, but again, not actually lodge that certificate as a judgment. And that gives rise to some interesting issues as well in terms of statutory demands and whether or not statutory demands on that basis can be set aside. And Declan will run through those issues. I'll now hand over to Dinesh to speak to Scenario A, and that is where a payment claim is premised by a judgment.
Thank you, Andrew. Sorry, folks, for the technical delays, but these things do happen. We'll do the best we can to speed things up. I know it's Declan's bath time now, so we'll move on very quickly. For my part, I will deal with the typical ways in which statutory demands are issued in respect of a registered judgment, and they are usually founded upon the creation of a statutory debt under SOPA or otherwise an adjudication certificate issued pursuant to SOPA. Now, speaking to those issues, I will cover why such demands issued on those bases are difficult to set aside and why it is the preferred approach when issuing statutory demands. Declan will focus on the same issues, but in the context where no judgments have been obtained and how that creates a susceptibility for the demand to be set aside in those circumstances. Now, some of you will be very familiar with SOPA provisions, so please excuse me for reciting them in the PowerPoints, but I've done it for the purpose of those who are not so familiar. Coming to section 15 and 16, that is where a statutory debt is created. And under section 15, that is where a payment claim has been issued and it is not met with a payment schedule within the prescribed time and the debt has not been paid, and then it is open to the claimant to recover monies in a court of competent jurisdiction. Under section 16, and Declan reliably tells me that this doesn't really occur, but under section 16, if a payment claim has been issued and is met with a payment schedule indicating the amount the respondent proposes to pay and fails to pay the whole or part of that sum, it is open to the claimant to recover monies in a court of competent jurisdiction. If any of the circumstances in section 15 and 16 are enlivened, there exists a statutory debt capable of being recovered in a court of competent jurisdiction. It is section 15 and 16 that creates the statutory characteristics of what is described as statutory debts. If those debts, statutory in nature, is what gets registered as the judgment. A judgment in that context is typically obtained by way of a statement of claim, and it is subparagraphs 4 in both 15 and 16 that permits the claimant in the court of competent jurisdiction to apply for judgment either on a final basis or on a summary basis. The defendant respondent is not entitled to bring any cross-claim or raise any defences in relation to matters arising under the construction contract. With that said, there is one significant hurdle that the creditor will need to jump, and that is to satisfy the court that a valid payment claim exists. That usually requires the court to be satisfied with the criteria in section 8 and 13. I don't propose today to go into those sections. That's a debate for another day. But relevantly, Justice Einstein held in ISIS projects that a claimant who relies upon the provisions of this section must prove that a valid payment claim has been served and also clearly prove what is the due date for a progress payment. The other way in which you can obtain judgment is through the adjudication process. I won't go through that process for today's purposes, but the usual way in which that is undertaken and the relevant provision is section 17. It's the adjudication process that permits you to obtain an adjudication certificate. Under section 25, you will be granted a judgment if the criteria is met. Under this provision, the certificate is not deemed to be a statutory debt, but nonetheless, it is a debt arising from the functions of SOPA, and I'll cite an authority shortly for that proposition. So I've spoken in relation to the two scenarios in which judgments can be entered. So where to from here? Now that the judgments are registered, it is open for you to issue a creditor's statutory demand for payment of debt, otherwise known in short form, statutory demand, pursuant to section 459E of the Corporations Act. Now, most of you will be familiar that a debtor gets 21 days to pay the debt or challenge it. We're not here to talk about debts being paid, so let me get to these obstacles that need to be jumped when faced with a demand that has been issued with the benefit of a judgment. There are two principal bases to challenge a statutory demand, and they arise pursuant to section 459 capital H, being the genuine dispute argument or an offsetting claim. Dealing firstly with a genuine dispute, the question sometimes arises, does it matter if I have proceeded with issuing a statutory demand based on a judgment founded on either a statutory debt or adjudication certificate? Strictly speaking, no, you can't rely upon it as a ground of challenge, and I say strictly speaking because there are very limited circumstances in which you can raise genuine dispute, and Declan will speak to those and no doubt will take you to the case of Aldoga. The threshold for establishing a genuine dispute and offsetting claim is a low one, and Justice Robb conveniently said in J Group, the threshold for establishing either a genuine dispute or a genuine offsetting claim is a relatively low one, and it is sufficient that there is a serious question to be tried based on a cause of action advanced in good faith for an amount claimed in good faith, such as not to be frivolous or vexatious. So, in the context of a statutory debt, why the genuine dispute cannot be deployed on the registration of a judgment can be summarised by Justice Brehrer in Douglas Aerospace. For your convenience, I have cited the relevant paragraph, but more to the point, Justice Robb said in J Group, it must be accepted with respect that so long as a statutory debt created by the Security Payment Act exists, or a judgment issued under that Act remains in force, a company which is so indebted cannot genuinely dispute the existence of the debt for the purposes of Section 459 H(1)(a) of the Corporations Act. Having set the parameters for a statutory debt, it is no different to an adjudication certificate registered as a judgment. Whilst it might be a little bit easier to grapple with the concept that once you have a statutory debt and register that as a judgment, no genuine dispute can be raised, well, contrary to that, where you have an adjudication certificate, it might be asked, how come that can't be challenged in the context of a genuine dispute because it's not a statutory debt? Well, Justice Robb said it's a judgment issued under SOPA, and if it remains in force, it cannot genuinely be disputed while it's registered. To reinforce this point, the Court of Appeal said in Diploma, the question is whether there is a debt. If there is a debt which is due and payable by reason of state legislation, then there is no fictional state of affairs. So when the court refers to fictional state of affairs, it is an acknowledgement by the court that the adjudication certificate is the result of a statutory consequence, and the consequence is by reference to Section 25 of SOPA. For that reason, the court cannot and should not interfere with that by setting aside such a demand founded on that basis. Let us turn to the offsetting claim. This is your better argument to set aside a statutory demand based on a judgment either arising from a statutory debt or adjudication certificate. Your typical offsetting claim on a construction contract will typically be claims for defects in or otherwise incomplete works or damages for delay, which we know to be liquidated damages. A respondent to an adjudication application almost has these arguments available, and as a result, statutory demands based on SOPA judgments are susceptible to attack. Your offsetting claim does not have to relate to the specific construction contract. It can arise out of other transactions. The Court of Appeal best summarised this proposition in Diploma and Douglas Aerospace. I might just take the opportunity to just read those. They're short. In Diploma Construction, Poole and JA said, there is no doubt that the recipient of a statutory notice may successfully apply to set aside a statutory demand based on an adjudicator's determination or a consequent judgment if it has offsetting claims arising from transactions separate from those that give rise to a judgment debt based on an adjudication under the Act. And there Poole and JA submitted, withdraw that, Poole and referred to Demir. In the matter of Douglas Aerospace, Justice Brehrer said, thirdly, as to offsetting claims, the authorities on SOPA are uniformly consistent with the general principle relating to offsetting claims, holding that a true offsetting claim, for example, a cross-claim for damages for negligence or breach of contract, or the recovery by way of restitution of amounts already allegedly overpaid, may be relied on to set aside a statutory demand founded on an adjudication certificate. That is because the effect of 459H(1)(b) is that any claim the company has against the creditor falls within the definition of offsetting claim, and this is unaffected by any special features of the debt that founds the demand. So in summary, the paragraphs I've cited makes good the proposition that transactions separate from those that give rise to a judgment debt can be mounted as an offsetting claim. Such claims can include damages for negligence, breach of contract, and restitutionary claims for money already paid, which we typically know as the allegation of overpayment. In saying this, a challenge to an adjudication certificate is not an offsetting claim. A claim that the adjudicator got it wrong and that the debt is not truly a debt is not an offsetting claim. Justice Brehrer said in Aerospace that in respect of an offsetting claim, it has never been thought to extend to an appeal from or an application to set aside a judgment. If, however, the respondent has paid part of the adjudication sum, the subject of the judgment, it would be open to claim that sum as an offsetting claim. The difficulties you're likely to face when arguing offsetting claims is either the claim is not genuine or otherwise that the claim is not equal to or greater than the debt being claimed. This is always going to be a matter for evidence, and Declan will speak to that in his segment. Before I conclude, there is one other aspect of the Corporations Act that can be deployed to set aside demands. And I'm referring to section 459J of the Corporations Act. If there is a substantial defect such that the calculations are wrong in the demand, or that the demand itself is framed in such a way that it is incomprehensible to the debtor, then the court will set aside the demand. It is unusual, but it can happen. The some other reason ground is a last resort provision, but the courts will rarely, and I would go so far to say, will not engage with that provision in exercising its discretion, because with the debts registered as judgments pursuant to SOPA, there is harm in going behind an underlying judgment debt which has not been set aside and otherwise founded by statute. The approaches I have spoken to is the preferred approach, that is by issuing a demand on a registered judgment, because it is less likely that the statutory demand is susceptible to attack in respect of a genuine dispute. But where there is an offsetting claim, I can't make any promises. With that said, I'll hand over to my learned colleague, Declan Byrne.
Thanks, Dinesh. So as Dinesh has explained, he got the easy bit and I got stuck with the more difficult scenarios. So we're going to go through some of the cases, some of the very rare cases that deal with the circumstance where very brave souls had tried to issue statutory demands based off SOPA debts that they didn't get judgments for, and we'll have a look at what happened. I'm then going to pick out a couple of things of the practical consequences, the practical issues that you have to deal with in making applications to set aside statutory demands based on SOPA debts and in resisting such applications. So to start with, let's just go back to some basics. There's a couple of things you need in order to issue a statutory demand. You need a debt, it needs to be due and payable, and you need to be above the threshold amount. So the threshold amount is currently $4,000, and that's been in place since 1 July last year. Those of you like me will remember when it was $2,000 for a long period. And you might also recall that for most of 2020, the amount was temporarily increased to $20,000 to discourage these sorts of applications while everyone was in COVID lockdown. So the main question that arises out of all this, though, is what exactly is a debt? So helpfully, the Corporations Act does not include a definition of debt. Nevertheless, there seems to be acceptance in the case law that you give it its ordinary and natural meaning. And one such definition that's often used is that a debt is a liability or obligation to pay or render something. So I think the key thing to take away is that a debt does not include a claim for unliquidated damages. So given this broad definition of debt, it's apparent that it's not necessary before you issue a statutory demand that you first obtain judgment through the security payment process. You could, for instance, once a statutory debt arises under Section 15 where there's no payment schedule, or Section 16 where people don't pay, the principal doesn't pay what's set out in the payment schedule, which I agree with what Dinesh said, that so rarely happens. You can issue a statutory demand off that basis without taking the next step of getting a judgment. Now, those judgments are quite rare and for good reason. As Dinesh said, based on His Honour Justice Brehrer in Reed Douglas Aerospace, once you have a judgment, you're insulated from someone relying on a genuine dispute to set aside your statutory demand. You're essentially limited, the other side's essentially limited to an offsetting claim. If you don't have that protection, you are vulnerable to for parties to raise a genuine dispute. Let's have a look at some of the examples of this. So the first one I'd like to have a look at is a case called Gemzone and Triton from 2002, a decision of His Honour Justice Austin. The background facts to this one are riveting. You've got a plaintiff who's a hotel and motel developer, defendant's a builder. The defendant carried out work pursuant to a building contract in a motel in Gundagai. There was a payment claim for $178,000, which was said to be the final claim under the contract. Plaintiff issued a response denying that the the defendant was entitled, and then made a payment reducing what was claimed by about half. A couple of months later, the defendant lost patience and issued a statutory demand based off what was outstanding on the payment claim. And we have a judgment from His Honour Justice Austin. Now, interestingly, His Honour, the main point of the judgment was that His Honour found that the Act did not apply in this circumstance because the definition of progress payment under the Act did not include a final payment. Now, that's just due to some historical wording of the legislation. The argument there is that the progress payments are amounts you pay through the project. It doesn't include the final payment. To the extent that there was any doubt, the legislature changed the definition of progress payment after this so that it did include final payments. So that argument's off the table going forward. However, His Honour also noted that made some observations that would apply in the event that he was found to be wrong, and about the validity of the payment claim. Essentially, he found the payment claim would not have been valid if the Act did apply, because there was various non-compliances with Section 13. So that's the things that Dinesh referenced with Clarence and Isis Street. Ultimately, based on that, His Honour found that there was a genuine dispute in relation to the debt and set aside the statutory demand. Now, I don't want to dwell too much on the details of the case, because not only is the question of whether the Act applies to a final payment claim superseded by the legislation, but the various things that he relied on, that His Honour relied upon in Section 13 to render the payment claim invalid, have also largely been overtaken by changes to the legislation and the case law in the 2 decades since the case was decided. But the key thing to take away is this is an example where a court set aside a statutory demand based on a SOPA debt that was not supported by a judgment, and that was on the basis of a genuine dispute. So the next case I want to look at is, as Dinesh foreshadowed, the case of Aldoga and De Silva Star from 2005, a decision of His Honour Justice Palmer. So this was just a vanilla application to set aside a statutory demand. There was a huge amount in dispute. There was a sum total of $31,084.18, the 18 cents being the critical bit. There was a payment claim but no payment schedule, and the statutory debt arose. The main issue for His Honour to determine was whether, once the debt had arisen, whether Section 15(4)(b) of the Act, and if you recall, that's the provision that says if you commence proceedings to recover the unpaid amount, the other side cannot in those proceedings bring any cross-claim or raise any defence under the contract, whether that provision meant that you could not allege that there was a genuine dispute. His Honour Justice Palmer said, no, it did not mean that. You could raise a genuine dispute. Now, Aldoga raised a bit of consternation at the time because it was contrary to a lot of the other cases. And it was distinguished by the Western Australian Court of Appeal in the case of Diploma, which Dinesh has taken you to. And that is really the seminal case where the New South Wales position started, the current New South Wales position started. There, the Court of Appeal found that there cannot be a genuine dispute about an adjudicated amount. Of course, that was an adjudicated amount based on a judgment. And Diploma, as Dinesh has said, was adopted into New South Wales law by His Honour Justice Brereton in Re Douglas Aerospace. In that judgment, Justice Brereton rationalised the case law and specifically explained Aldoga by drawing a difference between those cases where you had a judgment and those like Aldoga where you didn't. So Reed Douglas Aerospace was a 2015 case. Curiously, later that year is the case of Justice Rob that Dinesh has taken you to, J Group. And in that case, His Honour made some throwaway comments that would seem to be contrary to what His Honour Justice Brereton said in Reed Douglas Aerospace, that said that you couldn't raise a genuine dispute in relation to a statutory debt, even if you didn't have judgment. So in the, 7 years since those cases came down, there hasn't really been a further exploration of that issue to resolve the ambiguity. And that's because there's just so few of these cases. No one really tries to issue a statutory demand without getting judgment. Or at least if they do, they don't press it to resist an application to set aside. Okay, let's now turn to a slightly different issue, and that's issuing a statutory demand based on an unregistered adjudication certificate. And this issue arose by accident in that case on the screen, which is Kuzami and All Seasons Air, a decision of the Full Court of the Federal Court from 2015. So 2015 was obviously a big year for this issue. This was an application to set aside a bankruptcy notice, not a statutory demand, but similar provisions apply. The judgment was based on a adjudication certificate which had been registered. The difficulty was, and what the case discussed, was that Section 25(2) of the Security Payment Act says that when you are registering an adjudication certificate, you also need to file an affidavit verifying that the amount claimed in the certificate is outstanding at the time of when you register. For whatever reason, the plaintiffs in that case forgot to do it. There was no affidavit filed, and so then there was discussion about whether or not it was a true judgment and whether they got the benefit of that. That is, that you couldn't raise genuine dispute. What the court found was, because the judgment had not been registered in accordance with the Security Payment Act, the judgment was a nullity, and as a result, it could not support the demand. So the inference seems to be that an adjudication certificate can't be enforced or used to found a statutory demand unless and until it is registered as a judgment. And I think it's important to note that Section 25 doesn't say once an adjudication certificate is issued, a statutory debt arises. And I think it's different to a couple of other states' provisions in that respect. So that's why it's really, you do have to take that extra next step of registering it. But in circumstances where you've already gone through the cost and hassle of going to adjudication, I can't imagine a circumstance where you wouldn't also be prepared to file a one-page form and fill out a one-page affidavit and register the judgment and get all the protection that provides. So suffice to say from, I think, these three cases that there's significant risk in seeking to found your statutory demand on a SOPA debt without first obtaining a judgment. Okay, I want to run through a couple of practical tips, and obviously there are huge amounts to say on security of payment generally and statutory demands generally. People have written lengthy books on both topics. I don't plan to canvass everything comprehensively today. I've just picked out three key points. So the first one is, what do you need to actually bring an application to set aside? So very basic. You obviously need an originating application. You need a supporting affidavit. Now, and the affidavit needs to set out the basis for your claim. So I think, as I've said there, the best practice in terms of setting out an offsetting claim is to actually have a pleading, preferably one that you filed in court. The next best would be to attach a draft pleading, and then after that you'd attach documents or explain in the affidavit the basis for the offsetting claim. But more support is better. However, technically speaking, you don't need to set it out like a formal pleading. Okay, the next issue I want to talk about is the verifying affidavit and the quite scary case of Mingtian Real Property and SGS Platinum from a couple of years ago. Now, this verifying affidavit is a different one to the one I was talking about earlier. This isn't the one that you have to file when you're registering an adjudication certificate. This is the one that is referred to in section 459E3 of the Corps Act. And that's one that says if the debt, the subject of the statutory demand, is not a judgment debt, when you're serving the statutory demand, it needs to be accompanied by an affidavit saying that the amount of the debt is due and payable. So the judgment obtained in this case had three components. One was the amount that was shown in the adjudication certificate, so the adjudicated amount, and that was for about, from memory, 400 odd thousand. To that was added a filing fee of $188. That's just literally to file the registration fee. And then there was an interest charge of $86.92, and that was the interest between the adjudication certificate and the registration date. Now, the debt identified in the statutory demand, the judgment debt identified in the statutory demand, included the interest and the filing fee charge. So that is the extra $260 odd. The statutory demand was then served without a verifying affidavit. The judgment debtor who received the demand then sought to set it aside on the basis of some other reason. The one that Dinesh said is pretty rare, which is true. And the some other reason was the lack of the verifying affidavit. So, what did the court say? As you can see there, the court said, whilst the statutory demand based on a judgment obtained under Section 25 of the Act is a judgment debt and does not require verification by affidavit, the position is different where the purported judgment includes amounts that are not stated in the adjudication certificate, such as filing fees or interest. He then goes on to say, nothing in Section 25 authorised the inclusion of such amounts of the deemed judgment created by that provision. We then go to the next paragraph, and there's quotes from Justice Black in re Cooper Brown, where His Honour held that the inclusion of such amounts in a judgment under Section 25 deprived the judgment debt arising under the Act of the exception that would otherwise be available under 459E. That is that you don't need to serve that affidavit. His Honour then continued, and the first sentence is the important bit. This has the necessary consequence that part of the amount claimed in the demand is not properly characterised as a judgment debt. So, what does that mean? If you're going to claim anything more than the adjudicated amount, you need to provide a verifying affidavit when you serve. Or conversely, if you're on the other side, if you're trying to set aside a statutory demand that includes a claim for things not set out in the adjudication certificate, you need to check to see whether there is a verifying affidavit. If not, you might have a ground to set aside the demand, as happened in Ming Qian. So because of the inclusion of that extra $260, the whole demand for 400 odd thousand was set aside. So that's obviously pretty severe consequences. Okay, the last thing I want to look at is the threshold for establishing an offsetting claim. Now, Dinesh touched on this. So the first thing to say about it, as he said, is it's a pretty low standard, which is either good or bad news, depending on which perspective you're coming from. So there's various ways of that the threshold's been described. As you see from those cases on the screen, a serious question, an issue deserving of a hearing. The other thing that comes through in the case law is the claim must be made in good faith. And the meaning for that is, what good faith means in that context is the offsetting claim was arguable on the basis of the facts that were asserted with sufficient particularity to enable the court to determine the claim is not fanciful. It's also been said that while it's not for the court to engage in assessment of the deponent's credit, this does not mean the court must accept uncritically as giving rise to a genuine dispute every statement, however equivocal, lacking in precision, inconsistent with undisputed contemporary documents or other statements by the same deponent, or inherently improbable in and of itself, not having sufficient prima facie plausibility to merit further investigation as to its truth, or a patently feeble legal argument or an assertion of facts unsupported by evidence. So the Court of Appeal has also said that an offsetting claim should have a sufficient objective existence and prima facie plausibility to distinguish it from a merely spurious claim, bluster or assertion. and sufficient factual particularity to exclude the merely fanciful or futile. Okay, so some closing thoughts. I think what you can take from the presentations tonight is that you can use statutory demands to enforce debts that arise under security payment legislation. I think you should also take that to mitigate the risks of doing so, to prevent the grounds of challenge, you should endeavour to obtain judgment first before you do that. However, even if you obtain judgment, the demands are still liable to be set aside on grounds for offsetting claim, if there's a valid offsetting claim. So while this isn't available, while statutory demands are available as an enforcement mechanism, recovery of the underlying debt using this means is by no means assured. And so I think this may lead to a lot of you, as some of my clients have previously done before, and ask, well, why would you even bother issuing a statutory demand? I mean, if you're the recipient of a SOPA judgment, the principal on the other side is almost always going to have an offsetting claim. So if it's inevitable that they're going to be able to set aside or at least challenge the statutory demand based on an offsetting claim, why would you even bother? Now, I think while most construction projects, there is always a basis to issue offsetting claims, and so you're likely to have that fight, the principal or the judgment debtor doesn't always win those fights. And for instance, I had a case at the end of last year where this is exactly what happens. There was a payment claim based on a security payment judgment. The principal alleged that there was an offsetting claim and just failed to come up to proof, just could not, in the time available, put on a claim that made any sense. And I think in that one, it was a case of Ree MacArthur, which was before Her Honour Justice Rees. I was acting for a superintendent, and it was the offsetting claim, or one of the offsetting claims that was asserted, was that my superintendent had breached a term of a contract to which he was not a party. And so Her Honour obviously had some difficulty with that suggestion. And so there are, just to give you some hope, there are circumstances where you can resist a statutory demand being set aside for an offsetting claim, and you can go on to use the presumption of insolvency going forward in winding up proceedings. So with that happy note, we're more than happy to take some questions. I think there's some instructions on the screen. If you want to raise your hand on the application or type a question in the chat box. If your questions are easy, Andrew and I are happy to answer them, and if they're really hard and difficult, Dinesh is your man. Unless anyone has any questions, I think we might leave it there. Thank you all for joining us this afternoon, and we look forward to seeing you in person next time.